Welcome to part 2 of my discussion entitled, I Just Need a Simple Will and Other Lies We Tell Ourselves. If you haven't already, I highly recommend that you go to my YouTube channel and check out part 1 of this discussion, where we talk about 2 legal documents that I think are actually much more important than a will. Today, I'm going to give you an example of why a will might not be enough for your planning or why you might not need a will at all. As always, this is not legal advice. This is general information. Important details may be left out for clarity's sake. If you need legal advice about your specific situation, be sure to consult with an experienced elder law attorney in your jurisdiction. A will, according to the official Merriam-Webster dictionary definition, is a legal declaration of a person's wishes regarding the disposal of his or her estate, or in plain English, something that you write up that says what happens to your stuff when you die. However, did you know that a will is not the only way to transfer property after you die? Did you know that there are actually other ways that property can be transferred, and that some of these ways might actually override or control what happens to your property regardless of what your will says? So, you think you might need a will, but depending on how your assets are titled, you might not need one at all. Let's briefly talk about ways that property can be transferred after you die. Property can get transferred by a will, but it can also get transferred if there are 2 joint owners on a bank account and one dies, if there are 2 owners of real estate and one dies, if something has a beneficiary designation, and assets can also be transferred through revocable trusts. Again, the best way to illustrate this, I find, is through an example. In part 1 of this discussion, we talked about Joe and how Joe's lack of planning impacted some of the things that happened to him. So in part 2, I'm going to introduce you to Bonnie. Again, Bonnie is not a real person, but she is a combination of many of my clients who have been in similar situations to Bonnie. Bonnie is going to do some planning, but it's going to be planning that she does without getting good legal advice, and it ends up having some unintended consequences. Remember again that this is just an illustration for general information. It's not legal advice. Remember, every state's laws are different and everyone's specific situation is different. So let's get back to Bonnie. Bonnie is 70 years old. She's divorced and she has 3 kids. She has a house that's in her name only and is worth about $300,000. She has a checking account and a savings account, and on that checking and savings account, she has added one of her children's names to those accounts as a joint owner. She also has an IRA, and her ex-husband is still named as the primary beneficiary. Her 3 children are listed as the contingent beneficiaries in equal shares. So Bonnie knows that it's important to plan. She wants to make sure that things happen and go the way that she wants them to when she dies. So she goes online, she prepares a will for herself, and in her will, she leaves her assets to her children in 3 equal shares. So in this example, when Bonnie dies, who is going to get her assets? Before we talk about what happens with Bonnie's situation when she passes away, let's talk some more about wills, jointly owned property, beneficiary designations, and revocable trusts. If you understand these things better, then you'll have a better understanding of how Bonnie's assets will be distributed when she dies. Let's start with the most well-known way that people pass assets when they die, through a will. As I've said already, wills are not the be-all and end-all. A few things that people don't realize when they create a will. Wills are public. Wills don't plan for incapacity. Wills don't control all of your property. We're going to see that in a few minutes. And wills may require you to open an estate and go through the probate process. The other thing that people don't really think about or understand is what happens when you have jointly owned property. If you have your child or your spouse on a bank account as a joint owner, you most typically own that as joint tenants with rights of survivorship. That means that whoever of you dies first, the bank account will go 100% to the survivor, regardless of what your will says or regardless of what your intentions are about that money. Where that money goes is not controlled by what your will says. The ownership on the account, if it is jointly owned, overrides whatever your will or your trust might say. If that's not problem enough, keep in mind that you cannot add instructions onto the ownership of an account like that. So you have no control of where that money goes if something happens to you. As I said before, it may not go to your intended beneficiary. It cannot protect any of the owners of that account from getting sued or getting a divorce. And it does not have any instructions for taking care of a minor child with that money. And as I said before, the ownership, the joint tenancy, overrides what your other estate planning documents might say, such as your will or a trust. The same is true for an asset with a beneficiary designation. What the beneficiary designation says controls what happens with the asset and overrides whatever your will might say. Now that I've given you a little more information about what a will does and how there are some other ways that property might be transferred when you die, let's go back to Bonnie and talk about her situation. With this new information, let's take a look at Bonnie's situation and think about what Bonnie might have wanted to do differently. As a reminder, Bonnie is 70, she is divorced, and she has 3 kids. She did a will online, and in that online will, she leaves everything equally to her 3 children. She has a house in her name only, which is worth about $300,000. She has a checking account and a savings account on which she has added one of her daughters as a joint owner. And she has an IRA that names her ex-husband as the primary beneficiary and her kids as the contingent beneficiaries in equal shares. So based on what you've learned so far, what is going to happen with Bonnie's assets when she dies? Her will says that everything is to be divided equally among her 3 kids, but we've just discussed that that might not be what happens at all. What could Bonnie have done instead of setting up a simple will? First of all, Bonnie could have set up a revocable trust in order to avoid probate. If she had transferred her house in her sole name into a revocable trust, she would not have assets over $30,000, which is the probate limit in Newcastle County, Delaware, and her kids would not have to open an estate at the Register of Wills. As you remember, I also said that Bonnie had her checking and savings accounts jointly titled with her daughter. By having these accounts jointly titled with her daughter, when she passes away, those 2 accounts will be solely owned by her daughter and will not get divided 3 ways, even though her will says that her wishes are that they be divided 3 ways. Bonnie also should have updated the beneficiary designation on her IRA. As we discussed before with accounts with beneficiary designations, the beneficiary designation controls what happens to that money. It doesn't matter that Bonnie said that her 3 children would receive her money in her will. What her beneficiary designation says trumps what her will says. So at least in Delaware, her primary beneficiary on her IRA is still going to be her ex-husband. That is who is legally entitled to her money. Bonnie also could have discussed this plan with her kids. Then they would have had a better idea of what her wishes were and also how she was expecting her assets to be distributed when she passed away. So what does this mean for you or your family member? What can we learn from Bonnie's situation? If your family member does not have estate planning documents, they need them. But when I say estate planning documents, I don't just mean a will. I mean that you need to sit down with an attorney and look at the whole picture. You need to look at all of your assets. You need to look at how they're titled. You need to talk about how you want them distributed. And you want to make sure that the way you want things to go is actually what your documents say. And not only that your accounts are actually titled and your beneficiary designations are updated so that everything works together and flows the way you want it to. If you or your loved one already does have estate planning documents, it might be a good time to review them. When is a good time to do that? There are some trigger points where I can say you definitely need to go to an attorney to have your estate planning documents reviewed. If your documents are more than 5 years old, you should probably get them reviewed. If you have some kind of major life change, like your children are now out of the house, you retire, your spouse passes away, you are diagnosed with a chronic illness such as Parkinson's or Alzheimer's, then that is also a time where you should go to an attorney to review your estate plan. If your documents were prepared online, then you should definitely go to an attorney to have them reviewed. Unfortunately, because of all the different reasons we've discussed, most of the time that I have clients come in who've prepared documents online without personalized attorney involvement, they don't reflect what the client's actual wishes are because they didn't understand the interplay of how their assets work with their will or their trust. If you're worried for any reason that your documents might not be sufficient, then you should go have them reviewed by an attorney. So to recap, when you think of estate planning, remember that it's not just a will and it might not be that simple. Durable financial powers of attorney and healthcare directives are the two most important documents to have in place while you're alive. And remember that when you're gone, different assets pass differently at death. Assets may pass based on joint ownership, based on a beneficiary designation, whether they are owned by a trust or whether they are part of your estate. And make sure that whatever your plan might be, it works together with your assets. Also, you shouldn't just put your documents on a shelf and forget about them. If you've had any of the life changes that I talked about, then you should definitely revisit your estate plan. Thanks for watching. Please be sure to check out my other videos on my YouTube channel.